are a lot of litigations which are initiated by lawyers themselves. So we are, as a community, far more socially conscious. We have always been, not even in India, but everywhere in the world. The battles of freedom have been led by lawyers. And I think among professionals, I think the lawyers are the foremost to claim the rights for themselves as well as for their fellow human beings.
Hello and welcome to the Superlawyer YouTube channel. Today we are here once again with an eminent personality and a person who works a lot in the field of dispute resolution, venture capital and private equity, retail trading, licensing and franchising, and real estate as well. He is none other than Alishan Naqvee, who is the founding partner of LexCounsel, law offices with extensive experience in laws governing and affecting businesses and individuals in India. He is appreciated majorly for his ability to suggest innovative solutions for any legal issues. He commands a leadership position and authority in India in areas of biotechnology and healthcare. He has been a regular face before most courts and tribunals in Delhi NCR. He also represents reputed clients in arbitration. Welcome, sir, and thank you so much for accepting our invitation to be here and give us your precious time. Welcome. Thank you so much, sir.
Thanks a lot, Divya. It's absolute pleasure to be with you today.
Let me start with the very important and most pertinent question you must have been always asked. With more than 2 decades of legal experience and background in physics, what was the inspiration for you to transition to law? And how has your scientific education, specifically related to physics, influenced your approach in legal practice, sir?
So, Divya, I would call myself, come to the bottom line, I am an accidental lawyer. I did not set out to be a lawyer when I was doing my graduation in physics, or even before that when I was a science student, 10th and 12th standard. But as the things happened, I ended up giving the entrance examination for law, getting selected. I had, of course, given other entrance exams also, mass communication being one of them. Briefly, I have also served in the training in the Indian Armed Forces. In CRPF, I was an assistant commandant for a brief period. Then I came back and joined the practice of law. So yes, I tried various things in my life and finally settled in law. And that's how, I started. Now, having started in law and with a background of science, I think it gave me immense experience and ability to analyze things. Because what science typically does is science gives you an ability to analyze things. And there is also a very strong sense of logic. So logic and science go together, hands in hands. So while I'm a physics honors graduate, of course, chemistry and mathematics were also the subjects. So I think it has helped me immensely with my analysis of law. When I came into law, analysis of the real issue, the real problem. So problem solving approach is another thing which the science students usually do. So that is on the aspect of practice across sectors. Now, how it also helped me in various sectors, because telecom, when I started in 1998, when I graduated and qualified law, then at that time, telecom was starting, telecom and IT, outsourcing. Now, all those things I could understand very well. And I also worked on when the lease lines came into India, when VoIP was started, voice over internet protocol. At one point of time, we had a regulation that on your PSTN connection, that is on your landline connection, the internet calls cannot terminate. So you have to have separate devices. So I am from that time. Now today, if you see, your internet and calls are on the same device, which is a mobile phone. So these technologies I understood well. I think, though I was a junior associate at that time, working with my seniors, but I think my knowledge of law and the background brought me to the focus and the forefront, and so many things I was handling with the client myself. So it was immensely helpful for me. Now, going forward, how the knowledge of science helps you? As you know, we have a very established healthcare practice, and I lead it. We'll talk maybe if time permitting about it a little bit. Artificial intelligence, machine learning, medical devices. There's a lot of debate around privacy, data protection. So while academically all these things are good, but if you look at it, there is a deep-rooted science, how the platform work, what is a anti-competitive practice, what the platforms can implement and what they implement. So from data protection, data privacy, artificial intelligence, machine learning, deep learning, there's a backbone of science. And I think the lawyers with science background, typically they think that you will become a patent lawyer, you will go into intellectual property. Not necessarily. I mean, I handle criminal cases also. I'm fortunate to have cases and experience across sectors. That's how we have built our practice. Forensic, every criminal case has evidence. Even civil cases have evidence. You have chats, you have WhatsApp messages these days. You have a domain registry if you go to intellectual property disputes. So if you have an understanding and knowledge of science, you can decipher and read those documents far better. So I think my background of science has been immensely helpful in my practice of law. I never expected it to be, because typical idea is that if you have done graduation of physics, why do you want to do law? And if you have to do law, you go to intellectual property. But my experience has been somewhat different. I have benefited from my knowledge of physics and science in general in my practice on a day-to-day basis.
Wow, sir, thank you for picking up that favorite topic of mine. Because of my engineering background, I'm also asked a similar question. After engineering, why law? And if you had to do law, why engineering? So there have been always these questions, and I would request you to answer some of them in this interview, if possible, if obviously time permits. Given the fact that since you were talking about AI, machine learning, even robotics, drones, and everything, for a person from a science background, given the fact that they know physics, chemistry, mathematics, preferably biology as well, it becomes very, very easy for them to decipher whatever is going on and relate it to law. But with that particular knowledge and the knowledge of law, also comes the understanding of the challenges that we may be facing in future that is related to ethics, morality, and the kind of concepts that artificial intelligence cannot be prompted until unless it has been fed in by the people who are developing it. So, sir, your views about this also. I would request you to tell us about the kind of ethical challenges that you foresee that we may be encountering, even with the forensic evidencing part as well. If we introduce AI into it, how is it going to impact the legal abilities? How is it going to impact our society at large? Because at the end, law is for the society, it is for the betterment of it. So, how do you see that all these emerging techs, even IoT, blockchain, all these aspects, how are they going to impact our lives, especially keeping India as one of the biggest countries in terms of population? Please, sir.
See, I also tell people often that India as a country would play a very significant role in AI, because the large part of AI development, the software and the generative AI, would either come from India or it will come from Indians who are based abroad. If you look at it across the world, the IT companies are heralded by Indians. We have a dominance over it. Now, when it comes to use of AI in the area of law, I feel there are three stages to it. The basic stage is where the volume work can be done by AI. For example, today we have traffic challans. It's all electronic evidence. Person is driving at a particular speed, the camera clicks a picture, the challan comes in. There is, of course, a discretion involved at that level, but discretion is only in terms of monetary penalty. It is not a matter of life and liberty. So one is that kind of a cases. Second are the cases which are volume cases, which are plaguing the judiciary. They have recovery cases from the banks, small amounts. A lot of disputes with the builders, which are there. Some amounts may be higher. Credit card, telecom companies. These are the bulk of the cases. A lot of these cases can also be sorted using AI in the core technology. And the basic judgments or the basic directions can be written by AI, which can be checked. So you can have a maker checker concept to free up the judicial time. Judicial time is extremely precious and extremely expensive, and taxpayers pay for it. But at the same time, sometimes you have some small petty matters and we all go to the courts. I mean, especially in lower courts, which do not have a pecuniary limit like high courts, sometimes the small amounts, small disputes take years altogether. I came across a case, in fact, till the Supreme Court it went, where a rental dispute involved 25,000 rupees per month. And the case was contested for 17 years. Finally, in the Supreme Court, the tenant was given 6 months to vacate. Now you imagine the amount of judicial time that has been consumed in these kind of cases. So some of these cases may be dealt up, sorted with the AI. Of course, AI being at that level where it can make that choice, and you write the judgment on sample basis like audit happens. An auditor does not check each and every entry of the books of accounts. It is on sample basis. Same way, we have this bulk of the cases, judicial time we can free up. Third is the most important aspect of judiciary. A judgment on a crucial issue without compassion shall not take place. We know. We always have liked and we expect our judges and judiciary to have compassion. because ultimately everything is related to human life and liberty. These are the top of the cases, which include huge issues like privacy as a nation, our policy, which can include the criminal offenses where life and liberty is compromised, which can include white collar offenses, which they say is against the public policy now, because when you hurt the revenue, you hurt each and every citizen of India. That is right. You talk about the cases of corruption. These cases, of course, the judicial time shall be freed up for it. So to my mind, if AI is used with this graded approach over a period of time, that for small petty offenses, the challans will be generated, it will be sent, which is also happening. But at the same time, a kind of checking is done, and it is done. A person may have a right to appeal, and they do it. Unless they do it, the case finishes there. Second is where they write bulk of the judgments, but the judges check some of the judgments. Of course, there will be a right to appeal, but at least writing each and every judgment will be. Third are the cases which are more crucial. So categorization of the cases. And we have done categorization of cases when it comes to bail. We have categorized the cases in different categories. Honorable Supreme Court has done it in many judgments and also published the guidelines for it, that how the cases shall be categorized for purposes of bail. So the categorization is already there. So if we have these kind of cases and judiciary can focus on it, I think we will see some solution. So AI can be constructively used. Now, second part of AI is, interestingly, what they say that how the lawyers will learn. Of course, lawyers suffered a lot. And I understand they suffered a lot during Corona time. I felt sorry for the lawyers who graduated during that year. There was a problem in finding jobs. If they were finding a job, there was also a problem with not having hands-on knowledge of the court procedure, filings, because those are the things that you learn in the initial years, and they are very valuable. Third is guidance by your seniors, actual courtroom craft, court craft, ethics, how to present yourself, all these things. 3-4 years of gap is huge. Now they say AI will do a lot of documentation, drafting. So they say that there would be lesser and lesser requirement for advocates at the lower level to start with. But AI will not stop here. It's like when we came into mobile technology, it did not stop with that 1.5 kg satellite phone that we used to take. Today we have smartphones, and smartphones are again becoming bigger. But there was a fashion about 10 to 12 years back, they're smaller. So you had flip phones, you had smartphones. So it comes in cycle. But I think as AI will progress, there would be some impact. There has to be, we have to readjust ourselves. Every industry will have to readjust ourselves. Legal industry also will have to readjust itself. The lawyers have to readjust themselves in terms of research skills, analytical skills, using AI as the basic data as we have used the search engines. SCC, Manupatra, we are all trained to use it. So I think that is a major shift that will happen with AI. Of course, there are ethical issues because we have seen that generative AI can generate its own myths, fictions as against realities. You may end up quoting in a court of law a judgment which never existed. So all those things are there. So it does not make the job easy or difficult. It just makes it a little different. Like, for example, when we graduated, at that time, I don't think we had SCC came, but the database were not this vast. If you had to look for a case, you had to go to AIR manual. You had to look for a subject. You have to find the judgments. Then so many times in your law offices or offices, you did not have judgments. So you would go to different law libraries. Maybe you will go to ILS, you will go to Supreme Court, you will get the judgment out, you will get the photocopies done. You will mark the page, leave it. After the court hours end, then the photocopy will be done, you collect it. So the effort was finding the law. Now, if you go to a court in a matter and you have a good judgment and you bring it out there, then and there, you have almost won the case because a lot of seniors remembered a lot of judgments, but mostly the lawyers finding the most suited case in your favor was a ticket to a successful judgment, unless the judge knows a case which is contrary. Today, I think technology has been a great leveler. Everybody is armed with the same judgment because we all use the same search engines or the law libraries online, and we all have the same judgment. So the time that we save in finding law, like I was doing when we were going to Supreme Court, then spending time there in the library, that time your judgment comes in a flash. There are various search engines. Even now Google is, if you search on Google, now the AI itself now assimilates some points. The time that you save is not to be wasted. This is for the young lawyers, is not to be wasted because finding judgment is no more an achievement that it used to be. Today, your analysis has to be better than the lawyer standing on the opposite side. So the time that you save shall be spent in reading the judgment and analyzing. What does it say? What is the ratio? What is the arbiter? Whether the authority has been challenged, whether not challenged, is it final? Whether there is a SLP, where there is an appeal pending. notice has been issued, whether it is stayed, because all these things are required to, there are multiple facets to it which need to be checked. So yes, AI is a very interesting thing that is going to happen. And I think it will challenge Gen Z quite a lot when they come. But I'm sure Gen Z is so technology savvy that I don't think it will be a challenge for them. It may be a challenge for us. It's like our grandparents using mobile phone. It's not a challenge for us, it's there. So I think with time they will learn. AI will be a disruption, but I think overall it is towards the progress and it will make things better if we use it wisely. And that goes for everything. In India, we have prescription drugs available without prescription. To tell the truth, you can get any medicine except for the main contraband ones. So we exercise discretion every day. On our screen time, we exercise discretion. So on AI also, we have to use it in a very balanced manner, intelligently, and develop it also accordingly. I don't see AI as a devil. I see it as a helper. But technology shall not be our master. It shall remain our servant. Because humans should have the right to decide ultimately for the well-being of the society and well-being of heirs. And therefore, you cannot do away with the compassionate judges, is what I feel. Not now, not anytime in future.
What a beautiful answer from your side for my question. But again, I'll take you back to your forte where you head biotechnology and healthcare sector. Major issues have been coming up because AI, especially disruptive technologies, have been used majorly in healthcare sector in order to make sure that elderlies and even newborns get a lot of care from robots as well. Given that parameter, now, there have been ethical issues there because there are so many privacy infringements happening there. There are so many infringements happening on terms of how unethical practices have been happening or not happening because AI sees everything from perspective of positive or negative. So, given that fact, how soon do you see or think that we will be starting to talk about neuroethics and about the brain rights that the world now is talking about? And the talk has been going on for so long, but we in India still have not started talking about it in major platforms. Where do you see we lie in that particular aspect? Because we are one of the constitutions which heavily relies on right to life, right to privacy, right to freedom of speech, and everything. So that has been commercially used. The way the brain has been, it is said that the way AI is manipulating your brain or the way it has been developed. When do you see our laws going to pick up the speed and parliamentarians will come up with this, that we will be saving our brain rights in the way we want to?
Yes. So Divya, unfortunately, what we have seen much with the legislatures across the world, and more so in India, most of our key laws have come as a reaction and not as an action. So when something happens, that is when we go and overhaul the laws, whether it be criminal laws or it be any other law. I think the resurgence of AI is happening now. It has already happened to a great extent. The time for making the law is now, because if we don't regulate it now, we will always be reacting and not acting. And in any case, no law is cast in stone. Our constitution isn't. There are amendments which are permitted. So I think the more time we take in regulating any sector, it does no service. We took years altogether in regulating the medical device industry. And it is not a feather in cap. We brought it under the Drugs and Cosmetics Act. And then finally we notified and then we brought in our own law and with gradual application onto devices based on the risk criteria. Now, devices had software. Software was also classified as medical devices and should be. Standalone software may be treated differently, but now most of the devices will be working on AI. For example, devices which manage blood sugar level. There would be AI and deep learning based on it. So there is an individual body reaction, but also there is a mass reaction to something. So if somebody has 2 teaspoons of sugar, blood glucose will go up. That's a no-brainer. But at the same time, how much it will go up depends upon various factors. And whether it is plain sugar or whether it is mixed with ghee or mixed with something, it depends. So all those factors which are also incapable of being processed simultaneously in real time with human mind. So many times people we see with these kind of diseases are not educated, capable, or they don't have time to make very informed decision. In the background, these decisions can be made. At the same time, there are ethical issues, of course, with the neurosciences especially. Now, we see what they are trying to do with Elon Musk's company, what it is trying to do. There have been debate both sides, and I have largely been a support of that. Because during various studies that have been approved, not of this particular area, but generally the studies in neurosciences, there are many conditions where a person's brain has some intelligence or is capable of interacting. But whether it is because of a physical condition or a neurodegeneration in the spinal cord or anywhere, the person is unable to communicate. So the mind is not silent, mind is active. It may also happen, so many times we have seen that a patient in coma may shed a tear or two. You don't understand whether he is upset or it is just a natural reaction to any irritant in the eye. But imagine the ability of that brain to communicate directly. Today, the electricity wires which are there from the brain to different portions of our body, even to my tongue as I'm speaking, that signal in any body may be depleted, but the brain is there. So having the ability to make those brains speak. Second thing also, what is intelligence? Now, this is going again. I mean, I have a different view. Of course, ethical views are there, but I am very much in favor of, and it will happen in future. Brain preservation will happen. We have people who are extremely intelligent, where IQ is very high. Imagine Einstein or Stephen Hawking, if their brains could be preserved and the problems could be given to them. See, ultimately, it is preservation in the interest of humanity. You are using it for productive use. The tissue generation outside of the human body is possible. In fact, we represented a client in oncology, cancer, and their USP was that they were, because in cancer, you give different lines of treatment. And we dealt with the ethical issues in this particular matter, how the doctors will take that in India. If somebody is diagnosed with cancer, there are 3 or 4 lines of treatment. Now, the lines of treatment goes by the experience of the doctor. And if you have first line of treatment and it fails, then second line of treatment, nobody can take 4 lines of treatment. The human body cannot take it. But what they did is they replicated the tumor outside and in a clinical setting, a laboratory setting, gave all 4 lines of treatment together and then gave you a report, what is the chance of success of each type of report. And a staggering above 60%, the first advice of the doctor was incorrect. And this was the study in India that we did at one point of time. So if that is possible, preservation of brain is also possible. So much of intelligence, so much of wealth of intelligence. Today, what is it? I mean, if you look at internet, Google is great of intelligence of different people. When you search, people put their answers. You search anything, you'll find a YouTube video. Ultimately, if you look at it, it's not a video. It's somebody's intelligence. He has translated it into a video and put it in a medium which is accessible. But this production of intelligence and recording a person can do only during the lifetime. But we have known so many judges, so many philosophers, so many poets, having them with us scientists, it will extend the usability of the human brain beyond the natural life cycle. And I am actually in support of these neuroscience initiatives. There may be ethical issues, but ethical issues shall not stop us from experimenting.
Me too, sir. There was a time when I watched this small movie called Chappie, and there was a subconscious transfer. And since then, I've been thinking that when that will happen, I really hope that happens in our lifetime so that we can transfer our subconscious in some robot and it lives forever. I know it will have ethical, moral, and every kind of issues, but still, that thought in itself, it's so intriguing that you start thinking that, okay, there is a life beyond life also. So thank you so much, sir, for a supporter of that. All of this in the background, and still you also practice in so many other areas and dominate them. Very soon in your career you started your LexCounsel firm, and you practically work a lot in litigation as well as dispute resolution. So don't you face challenges in those fields as well? Because many a times obviously people tag you with a certain field that, okay, you are good in this. How have you proved your mental in that particular field as well? Because obviously we have our own skepticisms and thought process. And so one more addition to that question is, how do you see that the entrants, the ones who are entering the field now, can actually plan their journey? Because what happens is, if you stick with only one field, sometimes there is a possibility that you'll not grow as much you would have wanted. So what would be your suggestions regarding that?
You have asked a very interesting question, and I have quite a lot of observations on it. I'm just trying to give them in a random sequence. They may make sense to you. So first of all, I always felt when I started as a junior advocate, I always felt that I tried to do different work, you know, because my idea was, which was there, that law as a profession, it's a professional course, a professional degree. A professional degree essentially, in my understanding, means that you don't have to necessarily apply for a job anywhere and get a job and then start working in that establishment. A professional degree entitles you, while it gives you the opportunities of working with established businesses, companies, lawyers, etc., it shall also entitle you from day one to start your own practice. So law in that sense is a true professional degree. And once I ended up doing law accidentally, then I had this thing that I would at some point of time start my own practice. And I would try it. And I was very clear about it. I wanted to try it out for 6 to 8 months. And if my bank accounts will run dry, I would go and join the law firm bank. That was my idea. And it was very clear. I mean, candid and honest about it. Now, thankfully, our first client paid within 1.5 months. So our kitchen expenses continued to run. And then that has been a good experience. I mean, running my own law firm has been a good experience. Second thing that we have done is what I felt when you do different things, and I'm coming back to that point. So I did litigation also, which typically law firms do, winding up petitions, maybe 138 cases of their clients. The heinous crimes usually don't come to law firms. White collar offenses may come, but white collar offenses is a very new thing. It is after the Money Laundering Act, and the teeth were given really in late after 2010. So 2012, 15 onwards, actually the law grew teeth. Before that, it was just there. It was just a law. People used to confuse also. So if I have to be a professional, there are two ways to do it. We have also seen extremely successful professionals who practice in only one area. We have seen extremely successful professionals who practice only in one court, at the most one city. So a Delhi-based successful lawyer would go to Delhi High Court primarily. They will have a chamber there. They will go to lower courts, and they may at the most, if there is a matter of Gurgaon, they will try and schedule it on Saturday, go there. They may go sometimes to Supreme Court, but Supreme Court is altogether a different practice area. So that's how the practice is shaped. Also, we have very successful lawyers who are only doing, for example, intellectual property matters, extremely successful in that area. There are also lawyers who do criminal, also senior advocates who will do criminal matters also, civil also, with equal efficiency. So I have seen in this profession that every lawyer's practice is different. And they can be different buckets, whether you want to be a court-specific lawyer, you want to be a practice-specific lawyer, or if you want to have a wide bouquet of work, which is intellectually challenging, that you do litigation also, you do arbitration also, you do NCLT also, you do national NCDRC also. Not only that, you do disputes across India. Then I think you should take every kind of work that lands on your table or lands up in your office during your initial year, because those are the years when you learn everything. And whenever a matter comes in, I always tell people that the correct sequence of drafting anything is that you read the pleadings if you are the defendant, or you understand the client's case. First of all, you make the key issues. What are the issues for determination? Then do legal research on it. Then finalize it, either yourself or with your senior. Conclude your thoughts and then sit down on drafting. Most of the times I have seen people doing the reverse. That a plaintiff has come, they start sit down drafting based on their assumptions, what will be right or wrong position of law. And ultimately, when the draft goes up for review, some things are correct, but some things are incorrect because it's based on assumptions. So my first advice would be do every type of work that lands on your table, because law is a very long profession. As they say, lawyers don't retire, they just drop dead one day. So it's a very long profession. The more you learn in the initial years is the better. Second is the research. Don't go on assumptions until you have that instinct after 20 years of practice. And I have often seen with many lawyers, my colleagues, sometimes with me also, that instinct driven. We tell our juniors that no, there will be something. Just go and find out, you will find something like this. And then they find it. But that instinct takes years together to develop, maybe 20 years, 25 years. Until then, continue to research. And third is that there is no exception to the hard work. There is no Monday to Friday concept. There is no Saturday, Sunday holiday concept. There is no hangover permitted on Monday morning in office. So all those things are very much, and I'm being candid and clear here, that the profession of law is a demanding profession. One of my seniors used to say that it's a very jealous profession. The moment you ignore this profession and you give it a second grade treatment, the profession leaves you. You will not leave the profession will leave you. So I felt that. So devotion. Once you have decided to become a lawyer, you have cleared the bar exam, which wasn't there in my time, and you are wearing a collar and going to the court. Now give your 100% to it. Because there is no greater embarrassment than once you are 10 to 12 years or 13 years experienced lawyer, there is no greater embarrassment that a bright junior knows more than you. And perhaps you cite a wrong line of argument before the judge. You know, it's open court. If you are a litigator, it's open court. It's there. It's now available across the world. So there is a time to learn, and then there is a time to deploy that knowledge. If you don't gain that knowledge, what would you deploy later on? So then I have seen many lawyers quitting the profession of law after 10 to 12 years or doing some other work here and there, which is on the periphery of law. So unless you develop solid knowledge of law through hard work in the initial 10 years, in the beginning, it's okay. You may not have financial needs. Your parents will support you, but you will have a very tough time after you cross 7 to 10 years. This profession becomes far more demanding after 7 to 10 years. Unless you build a solid foundation in the initial 5 to 7 years, your building of your practice will always have cracks in it. It will never be stable. That's what I feel. And same goes for the law college also. When I started practicing, they used to say law is learned through practice. Who learns law in law college? Absolutely incorrect. I have felt in my experience, all the lawyers who have good CGPA now, earlier there used to be marks, now there is CGPA, they turn out to be a better lawyer. The person who have not attended classes, who have been evasive in their assignments, because you only deploy the skill what you learn. If you have learned the skill during the law college of hard work and getting results through it, you will continue to do it through a profession. If you learn the skill of making excuses, in profession also you will make excuses. Initial 2 3 years it may be fine, but then after 7 years, you may not be permitted to make excuses and leave the courtroom because you'll be facing the judge someday, you'll be facing a senior someday, you'll be facing a client someday who will ask the question. And to retain a client, you have to have the correct answer. So this is what my humble advice will be to all the young lawyers.
Not only a humble advice, it's actually an absolute truth which you're talking about, and that has to be learned. And the problem which I have seen is if you do not learn it in the initial days, there is a good chance that you will never learn, and you'll always keep on forgetting the trait itself, let alone laws and everything. And from college days, if you do not have a habit of reading, there is a good chance you'll never read, you will never learn to read also. All of these things impact the career itself. But the way you are explaining, so I would request you to also shed some light on the kind of experience that you have had while representing multinational corporations, because their needs are obviously very different from the kind of general litigation needs of any other individual or even the smaller companies which come to you. Venture capital funds, how do you understand all that aspect? Because that is not a science background thing, it must be something which you have learned over the years. How have you handled the HNIs? How have you handled the kind of complex corporate transactions or the kind of dispute resolution mechanisms which are followed in MNCs or bigger corporations? Because their arbitration and mediation and dispute resolution systems are absolutely different, and they are well settled across the world. You cannot follow only Indianized version or only jurisdictional version. It has to have an international law involved. How have you incorporated that in your firm? Obviously, it's your learning and you have built it in that manner. So kind of learnings that you have garnered from there, it will be very helpful for the learners to understand why they need to learn more about international laws, let alone anything else prior to this, but now it has become important with keeping in mind the technologies that are coming in.
A very interesting question, Divya. In fact, the brushes that most of the times the Indian employees of multinational corporations felt in early 2000 were related to the casual approach that India had towards bribes, towards file moving charges. In fact, Foreign Corrupt Practices Act permitted file moving charges, facilitation fee. Bribery was prohibited, but they understood that in some countries, the reality may be that there would be some file moving charges. But then came the UK anti-bribery law, which prohibited it. And most of the multinational corporations would be governed by both of them, if not one of them. Because the moment you have any office or business within UK, the law would become applicable to you. And I have seen instances where the teams altogether have been asked by the global compliance to just walk out immediately from the office and submit their resignation. And that has happened. I mean, this is the whole team because they just took something casually and they were asked to walk out. Now, slowly and gradually, with tightening of our own anti-corruption laws and also with media, with awareness campaigns, with trainings in India, which these international corporations impart. Now, the compliance level, as we see ESG, the compliance level is becoming stricter and stricter. So to some extent, it is becoming easier for us to explain to the Indian employees of this multinational corporation. And in fact, they are also very clear about it. These are the practices. Even if there is a business loss, we don't care. I mean, it's very clear. We don't have those difficult dilemma situation where the Indian employees have done something which is completely unacceptable and it blasts into a much larger issue. Now, I think What has happened, fortunately, with us is we tried to build our litigational practice. I will talk about. I mean, you have asked certain questions. I'm just answering them in my sequence. So, if I talk about the litigation practice, we started as a corporate and commercial law firm in 2004. I also had some clients of corporate and commercial area who had some disputes. So they said, see, we like you as a lawyer, you understand our business. You understand the franchise agreements, you understand our international transactions. There is a dispute that is coming out of it. So can you handle it? We would say, okay, fine, we'll do drafting. I would go to the court. Usually, when you deal with companies, the disputes are often when they go to the court are high stake. So you either hire an arguing counsel, engage them, or you engage a senior advocate. Now, we realized after a while that a lot of effort was going in even the smaller hearings, the day-to-day hearings, that we were briefing them, then checking their availability. And at the 11th hour, we were left in front of the judge because in many cases, seniors couldn't make it. So then we took a conscious call that let's try and give the clients a solution to their problem. Why do they come to the law firm? They come for the answerability, they come for the responsiveness, because law firms as a culture bring that. They will tell you before the hearing, they will send you an update of the hearing, which was missing. Now we have some of the litigators who have always been like that, and a large amount of litigators now are very responsive and they do it what typical into litigation practice. They are responsive, but this thing was missing. And most of our clients used to tell us that if we would hand out their client to some of the lawyer who are new did litigation work, and would say you handle directly, they would be calling us, we don't know, the hearing happened 7 days back, we don't know what is the order. So we started handling that. The next stage, we decided that the fee goes up the moment you bring in arguing counsel or seniors, because that's a per hearing fee. So combining that with us, that we start appearing. And now what has worked wonders with us is that we are one of the law firms that a large part of our hearings we do ourselves. I and the partners of our law firm appear. We are no more just the briefing counsels. We do the matters ourselves and we engage the seniors for specific hearings. So that is the rule. Now it controls the cost of the litigation also. It has happened both ways. Sometimes the clients have come to us and told us that you do the matter, we know, because over the years you have been doing, you can do this matter yourself. But at the same time, the stakes are high or become high, and the opposite side comes with a senior advocate, and then you tell the client that we can handle it. But of course, if you want, we can also engage a senior. Sometimes they engage, sometimes they don't engage. There is also the opposite thing that has happened. So many times the clients have come to us. They said, this is the senior on the opposite side. This is the case that is how it's been handled. We want necessarily it to be done by a senior. We said, okay, fine. We do some hearings. Then the seniors somehow couldn't make it for some hearing. We had to do it. And then the client slowly develop a comfort. They say, you decide. Whichever hearing you want to take a senior, you take it. Otherwise, you do it. So we have clients from both sides. But what has happened over this period now, we have the trust of the clients that we can maintain the reporting and answerability and competence of a law firm, timelines, everything. So we have set timeline that if I need a draft approval from the client, I would not send him a night and evening before the last filing date. We'll send it much in advance. We will send them reminders. So all that information tracking and follow-ups, along with the ability to represent it ourselves while the litigation expenses are also kept reasonable. I mean, that has worked for us. It may not work with everyone, but again, in legal profession, there is no single formula to success. As I said earlier in the conversation, you have lawyers expertising in different areas, different courts, and also in one area, one court that's there, and both are equally successful. That is what has worked for us.
Wow, sir, you have built a beautiful practice, and all of this also paves way for others to learn from as well. Because there used to be a culture where many a times people never had faith on lawyers. Now they are having that once again, all thanks to law firms like yours. So you have been practicing now well over 20 years, I would say. So over the years, you have seen legal profession grow in different ways. It has been an immense difference, like you said, from 1.2 kgs of satellite phone to now even 100 grams of phone or 50 grams of phone. So during that practice time, what kind of changes have you seen in the legal professionals also? Legal profession has changed. Legal professionals also must have changed, and you must have seen that. How have you seen that change impact the legal practice? This question, why it came to my mind, because you talk about ethical implications of AI. So what are the ethical implications of past 25 years of your experience, and what all you have seen? change that thought process? Because yes, thought process has changed. We have become more international in thought process. We have become rather more global in thinking. So how have you seen that global thinking impact Indian legal profession as well as professionals?
So, Divya, I'll start from that. When you are younger, so many times, so many things you take as a compliment, which actually was not a compliment. So, when we started the firm, I was 5 years into profession, 5.5 years, and I would talk to the clients on video calls, weren't there that often. You had video conferencing facilities, which most of the people didn't use. So, some of the times you had the clients from outside of India who you are advising and who have never seen you. And one fine day, they say, okay, we are visiting India. We want to come and meet you. And so many times they've just told me, oh, you are so young. I felt very good at that time. Now I feel that they were thinking that, oh, this guy has been advising us. He's so young. How much should we trust on his advice? Whatever crucial decisions we have taken. So it took me some time to understand whether it was really a compliment or it was an observation. I do feel that it was a combination of both most of the times. What has changed is I'm very happy that so many, it's a work in progress, but so many of your tribunals, your courts are environmentally conscious. And Corona ended up becoming a blessing to some extent. We lost many lives, we lost many people. The pain is insurmountable. It is something which should never happen again in the humanity. Everybody we know has lost a few people, friends, family, somebody. But what it gave to us is a adaptability to the virtual system and also courts. And then thanks to our Supreme Court and the Honorable Chief Justice, last Chief Justice, we ensured that virtual hearings have the filing systems anyway have been gradually, with Delhi High Court also taking a lead into it, have become less on paper and more electronic. I am pleasantly surprised with seniors arguing the cases, even complicated cases, with just their tablet. So this is an adaptability that has happened. And you sit with them so many times out of habit. I still ask our seniors that, do you, sir, want a hard copy files to be sent to you? This is just send a Google Drive link and bookmark the pages. And sometimes you haven't properly bookmark again and send it to us. That happens. So what I've seen is we are more environmentally conscious. More so, we are also more pragmatic in our thinking. And I think that's a generational change that has happened. There are, of course, some judgments that we have seen over the rights of LGBTQIA community, the decriminalization, etc. So keeping that debate to a side, generally isolated incidents. Generally, if you look at it, the law has been pragmatic, and there is a different breed of lawyers also who are ready to, they were always there, who are ready to take up environmental causes, take up social causes, assist the court, become court commissioners, NGT. There are a lot of litigations which are initiated by lawyers themselves. So we are, as a community, far more socially conscious. We have always been, not even in India, but everywhere in the world. The battles of freedom have been led by lawyers. And I think among professionals, I think the lawyers are the foremost to claim the rights for themselves as well as for their fellow human beings. They are the first one to raise the flag. But what I'm happy to see is that the Indian legal community not only is keeping pace with everything, because we are a complex society, if you know, multi-religion, multiracial, multicultural, sensitivities, very diverse. So the way our legal fraternity is emerging, adapting every change and acing it and trumping and winning it is really impressive to see. I'm very happy to see the way the judgments come from the Supreme Court, indexed, linked. So you click, you reach that conclusion. There are a QR code on the judgments of the Delhi High Court. So all these things are brilliant, and they may not be measurable, and there may not be a comprehensive list of it. If I tell you off the cuff, I may miss many of them. But the thing is, the overall change that we are doing and overall progress that we are doing as a community with answerability and responsibility is just fascinating.
Sir, all this positivity, and on this positive note, I would request you to share your motivation behind keeping on practicing law for so many years and many years to come. Like you said, you practice law till you are alive. Given the wide range of portfolio that you practice, how do you see keeping yourself motivated, keeping others around you motivated, and keeping the positive environment going on as you were talking about?
So, Divya, I think it's a very individual answer. What I feel as a person is there is a need that I have. It's an intellectual need. I have always felt this intellectual need of doing something different or creating something new. challenging myself every 2 to 3 years, be it in my personal life, be it in my finances, be it in my child's education, be it in my law practice. So same thing transforms here also. We try and add a practice area, maybe add a different stream to it, do something new, learn a new practice area. And I think that is what has happened over the years. We have, as a firm, and I as an individual, have so many different practice areas, which are all interdependent and also independent at the same time. So you have clients coming in healthcare who may have a requirement of litigation at some point of time, it comes in. Clients of litigation who then want to have their medical devices registered through us. So it is interdependent, but again, they are very different. We have done work for DPCO. So the product control order, which regulates the pricing of drugs and some of the devices. So we have represented clients in that area, and they have then engaged us with the core area of healthcare and life sciences. So I think over a period of time, what has worked individually for me, and the honest answer is that I tried to develop different practice areas and kept the curiosity of my mind alive. I never wanted to do repetitive work. And I can draft minutes because I was trained initially working in the corporate law team. I can draft minutes, I can write board resolutions, I can do all those things, I can do due diligence. But after a while, I did not find my passion in doing that because I felt it was becoming repetitive. So we started taking up litigation matters. Then litigation matters also we will take at one forum, maybe high court or lower court, original side. But then the white collar offenses came in, we took that. Then NCLT cases we started taking. So we have significant practice in NCLT also, which is a new practice because IBC was a new law. Companies Act also overhauled the earlier law, a lot of concepts changed. So law is anyway dynamic and changing. Firm has not restricted itself to one court, one tribunal. And I think that sheer philosophy has kept the intellectual stimulation alive. And as a result, over a period of time, you have many practice areas in many forums. And that is what keeps me going. The new challenges, the opportunity to learn new things. As it is said, everybody is a student of law. Once you practice law, you are forever a student of law. You are never a master of law. So I consider myself as a student of law and willing to study every subject of law that comes my way.
Thank you so much for being so candid, sir. And it has been an amazing journey over past. So many questions you have answered so beautifully. And I really hope that learners will actually get inspired by the way you have established not only yourself, your firm, but also established the legal profession in a different manner where you accept the changes also brought in by the disruptive tech, which you are very open about. Thank you so much, sir, for carving a time for us, for super lawyers, and for our learners to learn from you and your experiences. Once again, thank you, sir, for being here and accepting our invitation. It has been an amazing interview with you. Thank you.
Thanks a lot, Divya. Thanks for hosting us. Thanks to Superlawyer. Thank you very much. It has been an absolute pleasure talking to you. Thanks a lot. Thank you.